Continuing on Law Weekly today, reactions trail the move to appoint lawyers as justices of the appellate courts. Two senior legal practitioners share their views with Law Weekly. We also have a weekly recap of the top stories from the courts. Hello and welcome to the program. I am Shola Sheyeli. It was on Monday, the 30th of January, that the Nigerian Bar Association gave notice to all legal practitioners pursuant to Section 231, subsection 2 of the 1999 Constitution, that the acting Chief Justice of Nigeria had invited the association to nominate suitably qualified legal practitioners to apply for appointment as justices of the Supreme Court of Nigeria. Interested legal practitioners were then required to send their profile in before the 3rd of February. 6 days after the deadline, specifically on the 9th of February, the NBA released the names of 9 persons shortlisted for appointment as justices of the Supreme Court. The names were forwarded to the acting Chief Justice of Nigeria, Justice Walter Onoge. The NBA says that this followed a rigorous process of shortlisting done by a select committee chaired by the president of the NBA, Abubakar Mahmood SAN, along with 8 other eminent lawyers as members. Those shortlisted are Dr. Olisa Agbakoba SAN, Mr. Anthony Digbe SAN, Yunus Ustas Usman SAN, Babatunde Fabonolu SAN, Mia Essien SAN, Awakalu SAN, Professor Awala Amishi Adudu, Mr. Tajuddin Oladoja, and Mr. Ayuba Giwa. The 9 were said to have been shortlisted from a total of 89 persons who expressed interest. Similarly, the acting president of the Court of Appeal, Justice Zainab Bukochua, sent out a similar request for nomination to the appeal court, and interested legal practitioners were to apply before the 17th of February. Now, there are those who have faulted this procedure. There are even those who are radically opposed to the appointment of members of the bar onto the bench. Those who support the move say it will bring some reform and freshness to the bar, as these senior lawyers will bring their varied experience to count on the bench. I had a chat with a senior advocate of Nigeria, Bolaji Ayoride. His father was a former Chief Judge of Oyo State. For now, he has no aspirations of going to the bench, but he feels strongly that legal practitioners can aspire to the bench, but the focus should be on the High Court. Here's our chat.
I don't think it's an exercise that can be rushed. Maybe like all things we do, it appears to be an emergency approach. Although the talk about it has been on for quite some time, but in doing it, we need to get the structure very right, because it's about judicial reform. And yes, it's welcome, but I would like to see a situation whereby very sound lawyers, senior lawyers, who wish to go to the bench are actually taken in from the High Court and not compulsorily Court of Appeal or Supreme Court. So if you have senior advocates of Nigeria that are young enough, these days you have people coming in their late 30s, and after 2, 3 years, 5 years as a senior advocate, then the High Court might be a good place to go, and then you take it from there. It's about judicial reform. In England, where we absorb most of our practices from, most judges being appointed to the High Court bench are Queen's Counsel. So they come in at the ages of from 35 to 40 as QCs, and after 5 years, they go to the bench, and they start from the High Court. So it's welcome, but I think it's something that shouldn't be rushed. It's something that we should look at very well. I've seen the names being suggested. Some of them have indicated about 10 years ago that they wish to serve on the bench, and it's not new. We should encourage it, but like I said, we should have a proper structure, a proper reform, and even encourage very good materials to go into the High Court. Mind you, the High Court is where most of the work is done. I mean, that is not to take away from the very tedious appellate work that our judges do, but most of the cases are dealt with in the High Court.
So if I hear you properly, you think that we should focus more of this reform on the High Court?
Yes, I think there will be 1 or 2 cases. There will be excellent materials that we can throw into the Supreme Court or the Court of Appeal at different times. But as a matter of policy, I think the concentration should really be at the High Court, you know. Make the High Court bench also very attractive to lawyers who have attained the rank of senior advocate, to lawyers who have done very well in the academics, and to other lawyers who have had a very good practice and look forward to serving on the bench. So I think the policy should be geared more towards the High Court. If you have a very strong High Court pool, then you won't have issues about taking judges from the High Court to the Court of Appeal and to the Supreme Court. So I think the policy should be geared towards strengthening the High Courts, because that is where the bulk of the work is done.
One of the things that you've also alluded to is that there should be proper procedure and policy in place. What do you suggest as proper procedure?
Well, you see, appointments to the bench should go through a considerable period of vetting. Once, like they do in the past, they are usually invited. They're invited, then you vet them over a period. And the process of vetting should be, you know, confined within the judiciary itself, the NJC, which will have a significant role to play. It is perhaps disturbing to hear sometimes that traditional rulers suggest to governors who should be judges in their state